So Mark Twain said that you got to get your facts straight. You got to get the facts straight. Then you can distort them at your leisure. The kind of facts that may be judicially noticed are the ones that can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. That's from the Federal Rules of Evidence, Rule 201A2. Adjudicative facts are facts that are relevant to a specific case and are important in determining the outcome of a dispute. They are facts that relate to the parties involved in a dispute, such as what they did, where, when, and how. Adjudicative facts are used in the process of adjudication where the law is applied. Where the law is applied to them. What does that mean? It means a lot if you paid attention. Now, I'm going to get to the case law when it comes to filing a 42 U.S. 1983. Garth Brooks, I'm not sure who all. 1983, usually, typically, for shorthand, they use 42 U.S. 1983 to sue cops. That's usually how I've heard it. But you could use it for anybody who takes away your constitutional rights. They deprived you of your constitutional rights, your federal constitution, not the state constitution, then you could go through federal courts. 42 U.S. 1983. So I'm requesting from the U.S. District Court in Denver a judicial notice on the 5 folks supra. On these matters, a judicial notice of these adjudicative facts are relevant and material for federal case number 24 CV 1851. The court must take judicial notice if a party requests it and the court is supplied with the necessary information. Rule 201C2. An adjudicative fact is not a legislative fact. Rule 201. The Supreme Court has instructed the federal courts to liberally construe the inartful pleading of pro se litigants. So there's less stringent standards. That comes from Erickson v. Pardus, 2001. Boag v. MacDougall, 1982, and Conley v. Gibson, 1951, says that a complaint should not be dismissed unless it appears beyond doubt that the plaintiff can prove no set of facts in support of their claim which would entitle them to relief. Let's go back to the inartful pleading of pro se litigants. I like that language, meaning if you're pro se and you just kind of scribble some stuff on the piece of paper and it's shorthand and you don't have, your verbs aren't conjugated and your adjectives aren't very descriptive or lively, your adjectives aren't popping. The Supreme Court has instructed the federal courts to liberally construe the inartful pleading of pro se litigants. That beyond doubt that the plaintiff can prove no facts. That's also Bell v. Twombly, 2007, and Ashcroft v. Iqbal, 2009, and Haines v. Kerner, 1972. So, you can't just dismiss the complaint unless you say, there's no way you can prove the facts. You can't prove the facts. You can't prove it. You made up a bunch of shit, and you can't prove it. You can't do it. That's Conley v. Gibson, 1957, Twombly, Iqbal, and Haines v. Kerner, 1972. Plaintiffs cannot be expected to anticipate and prospectively oppose arguments that an opposing defendant does not make. Greene v. Solano County, 9th Circuit, 2008. When considering a motion for summary judgment, the district court's role is not to weigh the evidence, but merely to determine whether there is a genuine issue for trial. I absolutely love the way that the federal court does the 42 U.S. 1983. So not only are we going to liberally construe the inartful pleading of pro se litigants, and we're not going to dismiss it unless they're just making up a bunch of crap and they can't support their claim. But we're also going to determine if there's a genuine issue for trial, and that's essentially the main thing. You're not weighing the evidence. You're saying, is there a genuine issue for trial? Well, A, deprive B of their rights, and I can prove it because of A, B, and C. There's a genuine issue for trial. That's Tolan v. Cotton. Tolan v. Cotton and Anderson v. Liberty Lobby Incorporated, 1986. Generally, exhaustion of state judicial or state administrative remedies is not a prerequisite to bring in an action under Section 1983, Patsy v. Board of Regents, 1982. The Heck 1994 decision listed some state and federal remedies, but it didn't include a major one, certiorari. Heck itself was decided by certiorari. In Brandsburg v. Hayes, 1972, the Supreme Court granted certiorari straight from a Kentucky State Appeals Court decision. Brandsburg v. Hayes is actually kind of bullshit. It restricts the right to the freedom of the press, the First Amendment. Why? Because we got a criminal investigation. It was all about marijuana. The journalist had written a story about marijuana, and then the court said, okay, you got to tell me who your source is. And he's like, I'm not going to. I got freedom of the press. Brandsburg v. Hayes says, no, you don't have freedom of the press. Not if you're involved with crimes. If you're involved with crimes, then we need to see what the hell is actually going on. U.S. v. Nixon was also the same way. What, Nixon, you're going to hold the audio tapes? You got audio tapes for a criminal proceeding, and you're going to withhold them from us due to executive privilege? Not good enough. We have a criminal justice system. We need to figure out the facts of the case. And in order to figure out the facts of the case, we got this adversarial system. It's very important to figure out the facts of the case. So Brandsburg v. Hayes and U.S. v. Nixon, 1974, both say that stopping crimes, getting your facts straight, distort them at your leisure, but you got to get your facts straight. You can't hide behind the First Amendment. Oh, I got freedom of the press. No, you were smoking that hashish. You've been smoking from the peace pipe. And you know a bunch of people who are smoking that doobies. You're rolling them doobies and you're getting all potted out on weed. We know it. You got to give up your source. From Monroe v. Pape, 1961, 42 U.S. 1983 actually stayed dormant from 1871 until 1961. So it was almost 100 years later. And it was with Monroe v. Pape. And Monroe v. Pape is actually going to go against the defendant, against some bullshit cops. But they did say that they could use the 1983 claim. Then everybody started doing it. We have on numerous occasions rejected the argument that a Section 1983 action should be dismissed where the plaintiff has not exhausted state administrative remedies. The federal remedy is supplementary to the state remedy, and the latter need not be first sought and refused before the federal one is invoked. That's Monell v. Social Services, 1978, and Twombly, there it is again. Bell v. Twombly, 2007. SCOTUS, that's the Supreme Court of the United States. SCOTUS said that a complaint must contain sufficient factual matter to state a claim to relief that is plausible on its face. So you have person A who deprived person B of their federal constitutional right. Is it plausible? Is it plausible on its face? So they accepted the case, but they ruled against the plaintiff in Monroe v. Pape. I said defendants, I meant plaintiff earlier. The district court may sua sponte enter summary judgment if the parties are given notice of the district court's intention to do so and are given an opportunity to develop a factual record. So sua sponte is if the judge on their own. If the judge on their own just wants to go ahead and say, fuck this asshole. I'm going to go ahead and rule against it. Or sua sponte could be anything. I'm going to ask a question in the middle of these proceedings. I'm being all sua sponte. It's fucking Latin. Like that corpus derelicti. Oh my God. I just heard a story about corpus derelicti. You had this fucking case. Holy shit. Basically, it's just these two stoners, but they're like fucking fucked. So you got these fucking fuck stoners, man and woman, husband and wife, who had 2, possibly 3 kids. Never got their social security number, so we don't know if they have 2 kids or 3 kids. And then we only know that they killed their kids by the text messages that they sent to each other. He was sitting there drinking with a buddy, and he told his buddy he was drinking with that he had drowned his kids and had lit them on fire. Or he had buried them, and then 2 years later he redug them up and then burnt them in the fire. Which is fucked because you see, I mean, this is a horror story, frankly. You see earlier pictures where he's like, you know, putting the baby like real close to him. And then the husband and wife are texting each other. They're kind of like, "You're such a baby killer. Why are you a baby killer? You baby killer, you." And she's just kind of taunting him as if like she's going to go back to him because that wasn't big enough of a crime for her to say, "No, adios, amigos. I got to go. I've got to go." So apparently there's a Latin phrase, corpus derelicti, which says that if the only evidence you have is the defendant's own testimony, their own words, then you might not even pass out of the damn preliminary hearing. You might not even get to second base. Wait a second, all you got is the guy admitting to it and then the wife taunting him? Not enough. Case dismissed. What about the damn kids? Holy fucking shit. They drowned them? I mean, you know how fucking sick you gotta be to just take another life, but to take your own children's lives and then to brag about it to other people, and then to be the woman who's chastising the man as if, you know, "Hey, you didn't do the dishes. What are you, a dirty dish man? Look at this dirty dish man. Old stinky kitchen. Stinky kitchen." No, instead it's, "You dumb baby killer." And it wasn't a baby killer, it was a toddler killer, and there was 2 of them, and maybe 3. And so I'm thinking, I mean, it looked like they're like 2, 3 years old. More of a toddler killer. And we're going to go ahead and dismiss that case. Because of what? We don't know where the bodies are. And then I even heard this part, holy fuck. After he burns his own children in the fire pit, he takes pieces of their bone and makes a memento necklace out of it. To always remember, I'm going to always remember my baby boy. This is like Abraham Isaac shit. I'm going to always remember my baby boy by putting his bone around my neck. What happened to him? You know what happened to him. Yeah, you fucking killed him. You fucking killed him and then burnt him. That should be at least capital punishment, if not life in prison. Should it not? But we're going to dismiss the case because you don't have the body. You didn't take a picture of the body. A cop doesn't come and testify to a liar's lie. You don't have any evidence. Give me a fucking break. Sometimes you got to just establish justice. The end object of America is to establish justice. So sometimes it's not to break any of the rules, but you give some rules more weight than other rules. You got to establish justice. Who the hell would be like, "Wait a second, you broke their constitutional rights, that corpus derelicti," and that's not constitutional, it's Latin. But these fucking assholes, they just hear a Latin phrase and automatically shit their pants. Did he just quote Latin? Corpus derelicti? Well, goddamn. Here's $100. You get out of here. You get out of here. And I'm going to go drink some chocolate milk in Twombly. It's got to be plausible on its face. So over and over again, basically it's saying that a plaintiff, especially a pro se plaintiff, just has to barely make their case. Just barely make your case. Okay, is it plausible? Is there a possibility? Is there a genuine issue for trial? Is it plausible on its face? Pro se litigants, they have inartful pleading. Their pleading is not very artful. It's very inartful. You got to liberally construe their pleadings. So the district court may sua sponte enter summary judgment. That comes from Ciolo Tex v. Cottret, 1986. Where related to the court's decision to grant the motion to dismiss, the facts of the case and the inferences therefrom are taken from the plaintiff's amended complaint and are viewed in the light most favorable to the plaintiff. Shire v. Schauer, Scheuer v. Rhodes, 1974. Scheuer. The burden is on the official claiming immunity to demonstrate his entitlement. Butts v. Economou, 1978. The Butts case, well, according to the Butts decision, well, that's because you didn't take a look at Butts. If you get into Butts and you pay attention to Butts, you got to get really into the weeds. You got to get knee-deep into Butts. If you get knee-deep, maybe even all the way up to your neck in Butts, you'll see that qualified immunity is bullshit. Therefore, Your Honor, you've got to indict that marijuana plant. Federal judges develop a more national perspective. State judges are part of the same political community whose actions and laws are being challenged by federal law. Federal judges, being detached from the state political system together with the structural protections of independence they enjoy under the federal Constitution, make them more likely than state courts to recognize federal claims against state actions and laws that state judges would otherwise maintain. The court may take judicial notice at any stage of the proceeding. Rule 201D. Rule 201D. And that's it for now. So, a lot of case law there. And if you're filing a, 42 U.S. 1983, that'll be helpful to you because it'll get your case in there. You'll be in like Flynn in Oregon. And that's before we've even had a chance to begin.